Welcome back to No Apologies, where we are unafraid to speak the truth. I am your host, Lori Hins. With me, Carmen Sertola from Ladies of Another View. Glad to have her today. And before we go to our guest, I just have to explain a little something. So that weird thing where it says, it crosses it out and it says Hins, that's cool. But then the one at the end says, crosses out and says liar. I had a lady write to me an email and she's like, hello, enjoy your show, but what is with the X on Becker and the liar? What have I missed, she says. And I'm like, I need to explain that. So in a previous show, I'm going to do this really quick. In a previous show, it's a bit of a running joke because a viewer had accused Rick of being a liar. And so it was a mailbag segment that we did, and I feigned outrage, and I yelled at him, wait a minute, you've been lying to me this whole time, to Becker, and I ripped off my microphone and my earpiece IFB, and I marched out of the studio, and he was giggling uncontrollably because it was all staged, and he's a terrible actor, note to self. So, but it was pretty funny. So they're recycling that from that goofy joke that we did. So I pretended to march off the stage because he was lying to me. So with us remotely is Speaker of the House for the state of North Dakota, Kim Koppelman from District 13 in the 5th largest city of the state, West Fargo. And thank you so much for being with us, Speaker.
Well, thank you. It's great to be with you.
Welcome.
So our topic tonight is court packing and something called Keep 9.
Yes.
And also, we're going to talk a little bit about what we've done in North Dakota to thwart any court packing. So if you could just go through, I did pull up and grab the House Concurrent Resolution 3023 so that we could take a look at it on screen if we want to and read through it or whatever. But there it is there, and it's hard to read on screen, but it's a concurrent resolution urging Congress to propose an amendment to the United States Constitution to prohibit changing the number of justices serving on the United States Supreme Court, and that the amendment should state the Supreme Court of the United States shall be composed of 9 justices. That is the whole thing right there. It is 13 words, and they are great words.
Well, I represent District 13, so I guess that's appropriate. And thank you very much.
I guess it is.
There were 13 colonies as well. So
That's true. It's a good number. It was my basketball number, just saying. So, so you brought forth this resolution along with some other amazing people, too. I saw with you Glenn Bosch and Larry Koppelman, Scott Lauser, Chet Pollard, Burkhard Dwyer Wardner in the Senate, on the Senate side, and Mike Dwyer is my senator from my district. And so I was thrilled to see the list of people involved with bringing this forward, too. So can you tell me how it came about?
Sure. Well, as you may know, when we propose a piece of legislation, be it a bill or be it a resolution, the sponsor of that bill basically looks for co-sponsors, looks for people that they believe would be of a same mind, a like mind, and would want to be part of something. And we request, and once in a while people turn us down, but not very often if it's a good idea. And in this case, I wanted to ensure that a lot of the leadership of the legislature was part of this. And so obviously the majority leaders of both House and Senate are listed. You mentioned Senator Dwyer. He's a member of the Senate Judiciary Committee. This went through the Judiciary Committees in the House and Senate. And I, of course, chaired the House Judiciary Committee for many years before becoming Speaker of the House. And Larry Koppelman was the chairman of the House Judiciary Committee last session as well. So Glenn Bosch is our caucus chairman, our Republican caucus chairman in the legislature, in the House. And so it was a lot of the movers and shakers, shall we say, that were part of this.
Mm-hmm. Well, it is a very brief but very important 13 words. Let's put it that way, because so many attempts have been threatened, I guess. They haven't been made necessarily, but they've been threatened enough so that it seems like states really need to try to thwart this before it actually does happen.
That's very true. And, you know, in our lifetime, this is the first time I can remember any serious talk about packing the court. And that's a very serious threat because there's no more important check and balance against a power grab by either the legislative branch of government in Washington or a president in Washington than the Supreme Court. And if we make that more of a political animal than it already is, it poses a great danger. Back in 1937, which was before my time, I'm an old guy, but not that old, Franklin D. Roosevelt proposed packing the court. And of course, remember, he had a pretty strong majority in Congress. It was the days of the New Deal and all that kind of thing. But his own party pushed back. He wanted to change the court from 9 members to 15, and both Republicans and Democrats jointly said, no, we're not going to do that. But there's nothing in the Constitution saying that some president and some Congress can't do it. So that's why this amendment is important.
It is. It's vital. It's really important because just the whole concept of court packing means that a president could say put 6 different people on the court and make it 15 instead of 9, and if you've got that many people on that are appointed, and this is an appointed for life position, it could drastically change the country. There's just no doubt.
Be kind of like in a basketball game. If you're 10 points behind, maybe your team should have 8 members instead of 5, and go out and see what happens. It's
right. Let's see what happens.
And the court is too political an institution already. That's a whole other discussion. But
agreed.
Yes.
Making law from the bench is an issue, and that's a problem. But it would become far more political. It would make that look tame if presidents and Congresses could, at whim, decide to increase or decrease the size of the court. And that's why we feel it's important. 150 years of 9 members says something. And even Ruth Bader Ginsburg, who I don't agree with on much, the former Supreme Court Justice, said 9 is a good number. And I agree with her.
I think that's very true. And you're right. Actually, it's kind of, in some ways, I've heard that it's a bipartisan issue, and we'll be talking to someone a little later on today about that as well, because the people who have, brought forth the nationwide goal of Keep 9, and we'll talk about that in a little bit, they're bipartisan. There's a group of Democrats and Republicans talking about that. Now, this resolution...
That's true, and it shouldn't be a partisan issue. It's an American issue.
Right.
And in fact, the first person to introduce it in Congress was a Democrat from next door in Minnesota, Colin Peterson, who was defeated in his last run, but he introduced it in Congress, and there are Democrats and Republicans alike that support this.
Exactly. Yes. Now, this is a HCR, which is House Concurrent Resolution. So this is not a bill. This is a resolution. Would you speak to the difference?
Well, the difference is there are different kinds of resolutions. General resolutions can be just to make a nice statement about something, congratulate the such and such a town's football team for winning the state championship, or creating, whatever, just general comments. Bills, of course, are proposed, and if they pass and are signed by the governor, they become law. A concurrent resolution is something that is sent forward. It's concurrent because both the House and the Senate concur and agree. And it is the method that is used to propose amendments to the Constitution. If we propose an amendment to the North Dakota Constitution, for example, I chaired the Constitutional Revision Committee several years ago. That's how that happens. And so there are 2 ways to amend the U.S. Constitution. One is through an Article 5 convention called the Convention of the States. And you're probably familiar with those efforts. I'm not opposed to that effort, but a convention has never actually been called. It may. And that would be an interesting process if it happens. But every other amendment that we've adopted over the years to the U.S. Constitution, whether it's the 18-year-old vote, allowing women to vote, prohibition when it was established and when it was repealed, all those kinds of things came from popular support. So that's the path this resolution takes. It simply urges Congress to propose an amendment stating the Supreme Court shall be composed of 9 members.
Excellent, excellent. Nice. Well, when we come back, we're going to talk a little bit about the precedent of it, and also where the resolution actually gets sent, to whom and why.
Sounds good.
Stay with us. We'll be right back. Welcome back. You are watching No Apologies without Becker, actually, this evening. My name is Lori Hinz, and with me, co-host from the Ladies of Another View on Beck, 4:30 in the afternoons, is Carmen Sertola. Thanks, Carmen, for being with us. We've been talking to Speaker of the House, Kim Koppelman, remotely tonight about court packing and about a resolution, an HCR, so a House Concurrent Resolution. And Speaker, this resolution has been voted on by both houses already. Is it concurrent? Is it passed?
Yes, it is passed during our legislative session earlier this year. You had asked earlier about the differences between resolutions and bills before they become law have to be either signed by the governor or there's a provision in our Constitution that if a bill sits for a certain period of time and is neither signed nor vetoed by the governor, it becomes law. But are different in that the governor really doesn't get a say. It's strictly something that the legislative body in both branches passes. And that's what occurred here. The House and the Senate passed this resolution and sent it on to the folks mentioned.
Was it a close vote, or was it no contest, not even close?
I don't think it was a close vote. I was going to look at those numbers today. I've forgotten.
I know, I didn't either. I did not do my due diligence either, too, because but I would be willing to guess that it probably handily. Yeah.
And how long does the resolution stay in place? Is it forever now, or is it a certain time limit on it?
A resolution is sort of a statement, statement of principle, statement of purpose, a request to do something. In this case, it's the latter. And so, theoretically, a future legislature might feel differently about something like this, and they could, I suppose, pass a resolution saying, never mind. But until that were to happen, we're on record as a state of North Dakota. The legislature elected by the people to represent them has gone on record with the United States Congress saying, we think you should propose an amendment to the Constitution that states that the Supreme Court shall be composed of 9 members.
Now, it could be fewer than 9 members, could it not?
Not under this proposal.
Okay, but
this proposal would fix the number at 9.
Okay, but what I am saying is if the president decided at some point just not to fill any, could the court be lower than 9? Could it not be 7 justices?
There could be a vacancy for a period of time, but the actual number is 9.
It has to be 9. Yeah,
just like if a member of the House were incapacitated or unable to fulfill his or her duties, we have 94 members in the House. We could be down to 92 or 93 at a given moment. But that seat that would be filled at some point.
It just seems like I heard somebody saying one time, well, what if he, decided that he was going to, make that choice and change the number? Fixing it at 9 would fix that problem.
Correct.
Well, that is a good thing.
And of course, it's important to have it as an odd number because, you can't have a tie that way. And but again, it is for 150 years, it has rested at 9. In the early days of the nation, they did change the size of the court back and forth a little bit. But then it became wise in most people's eyes to say, we need to have a number that is traditional, that we depend on, that is constant. And that number should be 9, and that's why it's rested that way. But there's nothing that says it has to stay that way. And that's why, like so many other things, we believe it should be enshrined in our Constitution so everyone understands this is what our Supreme Court consists of, 9 people.
It's kind of interesting that they didn't enshrine that, but they must have done that for a reason. Everything the founders did, they did for a specific reason.
Right.
So nobody wants to second guess the founders.
Or it may have been that they just didn't think about it. Most of the courts, it's interesting to study the courts because the Supreme Court is enshrined in the Constitution. Most of the federal courts were created, and there's nothing in the Constitution saying they exist.
Right.
But they created and they do operate. So, I think the founders understood that things could be fixed, could be changed, could be resolved as we went forward. And this is an example of a long-standing tradition, I meant to say, that simply should be codified, or in this case, enshrined constitutionally.
Right. Now, HCR 3023 goes somewhere, doesn't it? I looked at the whereas, or the be it further resolved at the end of this concurrent resolution. It says that the Secretary of State forward copies of this resolution to a bunch of different people.
To the President of the United States, to the majority leaders of the U.S. House and Senate, and to our delegation, our members of Congress. And interestingly enough, the current status, I did check on that before coming online on your program tonight, and actually it's now supported by more than 200 members of Congress, which is pretty impressive. 179 members of the House and 24 members of the Senate. It has been passed in 19 legislative chambers around the country, state legislatures like ours. We were one of the early ones. We were sort of a trendsetter in that regard. And it is currently supported by over 1,000 elected officials around the country, state legislators,
fantastic.
Federal legislators,
like attorney generals and attorneys general and secretaries of state and things like that. And
exactly. And I should note, Kelly Armstrong, our congressman, who was my counterpart for several years, he chaired the Senate Judiciary Committee years ago for a few years. And of course, as I said, I chaired the House Committee for a long time. So we worked together on a lot of things. But Kelly is a co-sponsor of this resolution in the House, which is actually the House resolution is HJ Res 11, and the Senate resolution is SJ Res 9 in the U.S. House, U.S. Senate, respectively. And so we have support. In fact, the House, the current House one, as I mentioned, the first one was sponsored by a member of a neighboring state who was a member of the other party from me.
Right,
so
Colin Peterson. And
yep. But the current, yes, Colin Peterson. But the sponsor of the current measure is actually Dusty Johnson from South Dakota.
Oh, from South Dakota.
A lone congressman there. So we've got some good support among our neighbors as well.
Well, that is great. So we know that Congressman Armstrong is obviously in favor of it, but have you heard anything from our senators on this issue yet?
I have not, and honestly, I was not aware of that. I just consulted with one of the folks with the movement that is kind of in tune with it every day, and he said they have not yet. They haven't indicated that they don't support it, but they have not yet indicated their support, and I would certainly hope they would. I know.
But think about the math here. If we've got 24 senators now, and our 2 senators put us at 25 and 26, we've got a majority.
Right.
Yeah.
Right?
That's true.
Yeah.
So we may have to have a little conversation with them.
Well, people can certainly. That's not my purpose here to
Nor is it mine. I mean, that's not my. That's for the people to do. That's for you all watching to do.
But of course, I know Kevin and John both very well, and have served with them in various roles that they, various positions they held in North Dakota prior to going to the U.S. Senate, and since we've worked together on a lot of things since. They're both good people and good senators, and they should support it.
Yeah.
I agree. We'll find out what the people say, though. That's your job as citizens, is to contact them. Am I wrong? I mean, that's the goal. If you feel like we should, push this forward, then we just need to get the approval of our senators.
Very true.
Speaker, thank you so much for being on the program tonight and explaining all this, especially from the North Dakota perspective.
Thank you. And one more thing, just to give your listeners and your viewers the full picture here. The first step is getting Congress to propose the amendment. Once it's proposed, it comes back to the states to be ratified. So like every other amendment to the U.S. Constitution, it would again be before the North Dakota legislature to say, yes, we support this, a future legislature, because we'll have, of course, maybe several before this comes before us, and every other legislature in the nation. So the power of the states was clearly understood by our founders as well, and that's why the Constitution cannot be amended without the states' involvement.
All right, people of North Dakota, keep this on your radar.
Yeah.
All right, thank you so much, Speaker. We will have you on again. We really appreciate it. And when we come back, we will have another guest, this time remotely, and he is the former Attorney General of Tennessee, and he's going to speak to the nationwide effort on Keep 9. Stick with us. Welcome back to No Apologies on Beck. I am Lori Hinz, your host tonight at the Bourbon Bureau. Becker is off, but with me, Carmen Sertola from Ladies of Another View. And remotely from Tennessee, we have the former Attorney General of Tennessee. This is Paul Summers with us. Paul, thank you so much for agreeing to be on tonight.
Thank you for inviting me. It's a pleasure. Thank you so much.
So tell me about how you managed to get involved with the whole Keep 9 movement to begin with.
About 2 years ago, 15 former attorneys general convened, and they decided to push an amendment to the United States Constitution that would set the number of Supreme Court justices at 9. Of those 15 attorneys general, former attorneys general, 8 were Democrats and 7 were Republicans. So it completely was a bipartisan, nonpartisan group. They have proposed an amendment that reads as follows. It would be the shortest amendment. It's only 13 words. The Supreme Court of the United States shall be composed of 9 justices. Most people think that that's probably in the Constitution today, but it's not. A constitutional amendment forms a firewall such that a Congress and a president could not increase or decrease the number of Supreme Court justices so that it would be to their political advantage. That is called court packing, that is not a part of our democracy.
No, I absolutely agree with that too. Any logical person thinking about it would realize that once you muddy the waters and try to add that many extra people, you're going to, I don't know, if anybody have been in a committee before?
Exactly, yeah.
And as it is, 9 seems to be the perfect number, doesn't it, Paul? I mean, it's been a long, long history of 9 justices.
We've had 9 justices on the United States Supreme Court, Lori, for 152 years. We've had as low as 5, and then we've had as high as 10 justices. The 10 was in 1869, right after the Civil War, not long after the Civil War. It was changed down to 9. It has been 9 ever since. But it only takes an act of Congress signed by the president to increase or decrease the number of justices. Is 9 the magic number? All I can say and all our coalition can say is it's worked well for 152 years. Let's don't try to fix something that it certainly is not broken. But more importantly than that, our forefathers back in the late 1700s, 1789 is when our Constitution was ratified. They not only were smart, they were clairvoyant. They created 3 separate and equal branches of government. 2 were completely political. The executive branch and the legislative branch were completely political, but the 3rd branch was completely non-political. That is the judicial branch. They created the judicial branch such that a member of the judicial branch would be independent, would not be swayed by politics or polls. I don't even know if they had polls back then, but polls or political positions, but that they would abide by the Constitution and follow the Constitution. It's worked well. It preserves the independence of the Supreme Court and the judiciary, and that's why we need to keep it at 9.
Do you think that people, citizens, need to get involved in this effort?
Citizens definitely need to get involved. Our group, and we're a grassroots group, but that grassroots group that started with 15 former attorneys general, it's called the Coalition to Preserve the Independence of the United States Supreme Court. It's real simple. We're grassroots. We have an organization in Washington, D.C. It's called, basically, we call it the Keep 9 organization. I'll later give you the website if anybody's interested. We'd love for them, particularly from North Dakota, to call in and get involved. But to answer your question succinctly, yes, we do. But what we want to do first is we want to inform the legislators, both the legislators in Washington, that is your U.S. senators and your congressmen from North Dakota, but we also want to inform your state legislators as well, because the constitutional amendment process is twofold. You first have to have 2/3 vote of both the U.S. House and the U.S. Senate before the constitutional amendment is proposed, and then it has to be ratified, and it's ratified by 3/4 of the states involved, and that's either by the legislators voting it or having a constitutional convention. But at any rate, we have to get both the U.S. representatives and senators and your state representatives and senators. And that's why it's important that I hope that, now I may not pronounce his name right, but Senator John,
it's
is it
Hoven?
Hoven?
Hoven.
Hoven?
Yep.
Senator
Yep,
John
you did it right.
Hoven and Senator Kevin Kramer, we sure like for them to look at those 13 words and jump on board, just like it's my understanding that Congressman Kelly Armstrong has already done.
Right. We just spoke to Speaker of the House Koppelman about that too, and he told us that I was not aware that our Congressman Armstrong was on board and sponsoring this. This is exciting news. That's great. He's our at-large, and Dusty Johnson, who is the at-large single congressman from South Dakota, also involved, I believe.
Right.
Yeah. Okay.
Well,
so
we want the first thing we want to do is we want Keep 9 to be. We want people to be conditioned that when they hear Keep 9, that they're conditioned just like they are when they hear Coca-Cola.
Right?
They think of a cold drink. They may not drink Coca-Cola, but they think of a cold drink or cold beverage when they think of Coca-Cola. We want them to know about Keep Nine. Right now, we are the strongest constitutional amendment that involves the Supreme Court that exists. We have over 200 members of Congress, that is U.S. senators and congressmen, who either endorse or sponsor the Keep Nine Amendment. We have over 800 state legislators in America that endorse or will sponsor such a proposition if they need ratification. And then we have over 1,000 elected officials at the state level around the United States that support us. We've got a lot of strength, particularly for a grassroots effort.
So what people need to know is you're going to learn this phrase tonight. It's called Keep Nine, KEEPNINE.org, and we'll show that to you in a second. When we come back, we'll talk a little bit about that and a little bit about, I'd like to talk about the Madison Coalition as well. So join us. We'll be right back. Stay with us.
Thank you.
Welcome back to our fifth and final segment of No Apologies Without Becker, Unbeck. I'm Lori Hinz, and with me is Carmen Sertola, and we are talking to Paul Summers of Tennessee, former Attorney General of Tennessee. Were you a judge also? Is that correct?
Yes, I was a senior judge. I was also an appellate judge, and I was Attorney General. And then first thing I did in politics was I was a district Attorney General prosecuting cases at the state level.
Excellent, excellent stuff. Well, you got involved with this Keep Nine program in order to avoid court packing, and there are a couple of co-founders of that. Is that correct? Of the Keep Nine movement?
Yes, the coalition started with 15 former attorneys general, just like myself. Of that, half were Democrats and half were Republicans. This is completely a nonpartisan issue. They all realized, having been to the Supreme Court representing their states themselves, they realized how important it was to avoid court packing. And court packing is basically increasing or possibly decreasing the number of justices on the court so that you can fill them with people of the same ideology that you have, so that you can get the cases decided like you want them decided. That's not what our forefathers decided was an independent judiciary.
Not at all. Right. Now, people who want to learn more about the Keep Nine project, if you will, they can go to the website, and let's take a look at what it looks like. Keep9.org, KEEPNINE.org looks like this. It says court packing here. The Keep Nine Amendment has a large grassroots network of supporters across the United States. So you can go to this website and you can sign up to get involved, and you'll get some suggestions, I'm assuming. Is that correct, Paul?
That is absolutely correct. It's really easy to do. We're a grassroots organization. This is the shortest amendment to the Constitution, but one of the most important.
So I'm going to show you another slide, and this one is of the Madison Coalition. And the Madison Coalition is another similar group, but they're pointing people also to the Keep Nine Amendment. It says, as the Regulation Freedom Amendment, an effort to curb the power of future federal regulators, and the Keep Nine Amendment, an effort to ban Supreme Court packing, continue to build momentum. Please click here for the most up-to-date information, so you can get more information about several different freedom-loving things that you can, try to keep our representative republic intact as we go along here, Paul.
Thank you. Yep. Thank you very much.
Paul, maybe, and if I can just back up a little bit, because we were thinking, it's not often that we get a constitutional amendment in our country. Could you speak to that? When was the last time this happened, and what that process looked like?
The last amendment was the 27th Amendment. It was ratified by the states in 1992. It's impossible to determine how long it takes to have anything proposed or an amendment after proposed to be ratified. For example, the first 10 amendments, called the Bill of Rights that we're all familiar with, they were proposed right after the Constitution was ratified in 1789, and a couple of years later, the 10 amendments were ratified. That said, the 19th Amendment, which gave women the right to vote, it took 100 years to get it ratified.
Wow.
So
Wow.
it's impossible to say, but one thing's for sure, that no journey ever starts without anybody ever taking the first step. We're ready to take that first step, but we think that momentum is building, and we think that it will build where we can pass and then ratify the 28th Amendment to the United States Constitution.
So 2/3 doesn't seem like that daunting in the Congress, in the Senate, in the House. However, 3/4 by the states seems a little more difficult to achieve. But then when you realize that it is a bipartisan effort, this is not right or left. This is for the country.
Right.
It's not right or left. It's not at all. Just because the Democrats temporarily are holding power in Article 1 and Article 2 of the executive branch and the legislative branch, that won't last. 8 years from now, 10 years from now, however long it may be, the Republicans will be in charge. We don't care who's in charge. We just want to set it, like most people thought it was anyway, that we want there to be a firewall so that someone can't say, well, I want to pass a bill that obviously is unconstitutional, so let's pack the court so that all my bills that are unconstitutional wound up succeeding when they're attacked. That's not the way our forefathers envisioned. One more thing. We don't want to become a banana republic. We don't want to pack the court such that some child, say 35 years from now, looks up at her granddaddy and says, "Granddaddy, why do we have 39 members on the Supreme Court of the United States?" We don't want to do that.
Right.
Nine has been a good number for 152 years. The late Justice Ruth Bader Ginsburg said 9 seems to be a really good number to me before she died. Recently, sitting Justice Stephen Breyer, a Democrat also, he also said that 9 was a good number. Let's do what a bipartisan group, which, by the way, polls state that by a 3-to-1 margin of all voters, liberals, conservatives, independents, Republicans, Democrats, favor the Keep 9 Amendment, and with more moderates and conservative, is probably is more like a 4-to-1 margin of support. Wow. Bottom line is, let's do what's right.
Well, it seems to me that if you need something to unite the country, to me, this seems like it. I mean, when we are so split and fractured in so many different ways, I think this is a great opportunity to get involved, get behind something that you and people from across the aisle can all agree on.
Yes.
By the way, although I have never run as an R or as a D in any of my elections, I will always run as an independent. I tilt more to be a conservative. So I guess you could call me a quasi-Republican or at least a conservative. But our co-chair is the former Attorney General of Virginia, and his name is Steve Rosenthal, and he's a Democrat. So we're definitely a nonpartisan, bipartisan group. We just want to do the right thing.
That sounds terrific
awesome
to me. Well, before we leave here, tell people what's the mode of action they need to take.
Mode of action is, if you've got a voice with your United States senators, a voice with your congressman who's already on our side, but it sure doesn't hurt a thing to say you're doing the right thing, Congressman. We appreciate what you're doing. But talk to your U.S. senators, get them on board, and then after you've done that, talk to your state legislators, because we eventually are going to have to get this ratified by the state legislatures in 3/4 of the states.
Okay, talk to your senators, congressmen, tell them thank you, and then legislators. All right, you got your marching orders, people. All right, it's Paul Summers from Tennessee. Thank you very, very much for spending time with us. We really appreciate it.
Thank you so much.